So overall, in my view, the child abduction provisions in the Brussels IIa recast regulation represent a useful enhancements on the functioning of the regulation. And they do have, in my view, a potential to significantly improve the operation of the Hague Convention in intra-EU child abduction cases. So overall, I would view them in a positive light. And the importance of this reform, which was already overdue, is underscored by the fact that the Brussels II-based child abduction regime does not govern a negligible number of child abductions. If we look at the available statistics, we will see that in 2015, 71% of written applications received by EU member states, with the exception of Denmark, came from fellow Brussels IIa states. So this statistics comes from Professor Lowe's statistical report, and I will refer to his report throughout my presentation several times. So in my presentation, I will focus on what I see as the added value of the revised Brussels IIa child abduction regime. Nevertheless, I will highlight also a couple of areas where I believe the legislator could have taken a slightly different approach. So I will start with timing. The new provisions or new expectations with regards to timing. So we have recital 42, which explains that in written proceedings under the 1980 Convention, the courts at every instance should give their decision within 6 weeks, except where exceptional circumstances make this impossible. So this is then embodied in Article 24, and similarly, there's an expectation that enforcement of written orders will be carried out within 6 weeks. So that's Article 28. So we can see it as the 6+6+6 deadline, as it was referred to in the original explanatory memorandum. So we have 6 weeks for the court to decide at the first instance, 6 weeks on appeal, and 6 weeks for enforcement. So overall, the new timing provisions provide welcome clarity and realism. And as I want to refer to explanatory memorandum, this document itself puts it, this new 6+6+6 deadline envisages a maximum period of 18 weeks for all possible stages. This would render time limits for courts more realistic with a view to protecting rights of the defendant to a fair trial, whilst limiting it to the shortest period realistically possible. So these new provisions could be seen as dispelling the doubts that still surround the interpretation of the current Article 11.3, as it is uncertain whether this current timing provision includes appeals, although the practice guide does say that the timing, the 6 weeks does include appeals, but many commentators and courts do not believe so, and do not act, in terms of the courts, do not act accordingly. And it is also uncertain whether the current Article 11.3 refers also to enforcement proceedings, but that seems doubtful because the enforcement itself is not a convention obligation, so it's outside of the scope of the convention. So in practice, Article 11.3 is generally considered as applying to first instance proceedings only. Nevertheless, despite these shortcomings of Article 11.3, available statistics indicates that the provision has had a positive effect on the timing of court proceedings in regulation cases, with regulation cases being resolved by courts more quickly than non-regulation cases. Although the evidence may be seen as anecdotal to some extent, as Professor Lowe's survey covered only a period of 1 year, 2015, the finding is undoubtedly encouraging. And it is to be hoped that the new enhanced provisions will encourage the courts to dispose of written applications within the requisite time limit. So will enhance this, this further. Nevertheless, as Thalia has indicated or touched on, one of the issues is that there is not really any provision on sanctions for non-compliance with the proposed time limits. So this could be seen as a weakness or shortcoming of the new provisions. However, arguably, the timing requirement of Article 11.3 itself has been given some teeth by the European Court of Human Rights ruling, inter alia in the case of Shaw v. Hungary, where it was held that clear failure to meet the target meant that Hungary had violated Article 8 of the European Convention on Human Rights. So we can say that there is some teeth already there, which may have a positive impact on compliance with the new timing requirements. Now, going back to the requirement of 6 weeks for enforcement, in my view, that provision is particularly weak because although it is to be welcomed, it is a very welcome addition, it is undoubtedly weak because the wording of the provision basically just requires the enforcement court to inform the requesting central authority or the applicant of the reasons for non-enforcement within the 6 weeks deadline. So this is very similar to the general timing requirement under Article 11 of the 1980 Hague Abduction Convention. That has been seen as not very efficient in itself. So, but as Thalia has said, the added value is that it will at least increase awareness for the need for speed at the enforcement level, even if there is no provision with respect to the consequences of non-compliance with that provision. So now let's move on to grave risk and protective measures. So like the current Article 11.4, Article 27.3 states that a refusal to return a child cannot be based upon Article 13b of the Convention if the party seeking the return of the child satisfies the court by providing sufficient evidence, or the court is otherwise satisfied that adequate arrangements have been made to secure the protection of the child after his or her return. So if we look at these two provisions, unlike the current Article 11.4, the wording of Article 27.3 in the recast regulation makes it clear that the burden of demonstrating that adequate arrangements had been made to protect the child, this burden lies primarily with the applicant parent, although the court may use also other means of satisfying itself that the adequate arrangements exist. So this clarification, I feel that is to be welcomed, as currently this issue is not addressed either in the regulation or in the practice guide for the application of Brussels IIter. So I would see this as a welcome clarification. Another provision which is relevant to the application of the grave risk of harm defense, and which I would like to highlight, is Article 27.5, which allows the court that has ordered the return of the child to take provisional, including protective measures, under Article 15, with the view of protecting the child from the grave risk of harm. And such protective measures will then be enforceable in any other member state, including the requesting member state, and they will remain in force until a court of the member state of the habitual residence of the child has taken measures it considers appropriate. So that's Article 27.5, but also recital 30 addressing this issue. There are several other recitals that refer to protective measures and grave risk, in particular recital 44, recital 45, 46, and 59. So now, looking at the positive side of Article 27.3, so it is a useful improvement in terms that it's intended to make it more difficult for the courts of the member state of refuge to base a refusal to return on the grave risk of harm defense, by obviously providing stronger safeguards to ensure the child's safety upon return. So as such, I would see this provision as a useful improvement on the existing regulation. So making protective measures enforceable, that's certainly a positive addition. However, the concern I have with this provision and the recitals is that they refer or they concern only the protection of the child. There's no reference made to the safety of the returning parent. And indeed, if we look at the examples of protective measures set out in recitals 45 and 46, they make it clear that the regulation is concerned solely with the protection of the child. So just very briefly, for example, recital 45 sets out example of such adequate arrangements as a court order from the member state prohibiting the applicant to come close to the child, or a provisional measure allowing the child to stay with the abducting parent, who is the primary carer, until a decision on the substance has been made. So that's recital 45 examples. So the lack of reference to the safety of the returning parent is of concern, in particular in cases involving domestic violence. I feel that the provisions of the recast regulation should have made it clear that the risk to the child and the risk to the mother are often intertwined, and therefore, in such circumstances, in order to protect the child, the mother will also, usually it will be the mother, the returning parent will also need to be protected. Such protective measures, I feel that should fall also explicitly within the scope of Article 15 as indirect measures for the protection of the returning parent and being linked with the protection of the child. So alternatively, if the legislator was not prepared to acknowledge the link between the protection of the child and the returning parent in child abductions committed against the background of domestic violence, perhaps an explicit reference to Regulation 606/2013 on mutual recognition of protection measures in civil matters could have been made as means of facilitating protection of the returning parent independently of the protection of the child in separate proceedings, which would involve an application for a civil protection order that would then travel with the returning parent to the member state of the habitual residence. So these are my, or this is my main concern with the issue of protective measures. So that's grave risk and protective measures. Now I will move on to the override procedure, or the second chance procedure. So I personally have been very critical of the second chance procedure since it was first introduced in the current Brussels IIa regulation. And that's for several reasons. First, it seems to me that it creates some sort of disharmony between the Brussels regime and the Hague regime, child abduction regime. Also, it seems to me that it is overly complicated. It leads to confusion for parties, lawyers, judges, and also it may be seen as perhaps undermining mutual trust between the member states, by giving the opportunity to override a refusal to return. And besides that, research has shown that this procedure is rarely utilized, as a significant proportion of refusals are not based on Article 13, meaning that currently the override provisions are not triggered in those cases at all. So again, based on the 2015 statistics, that the statistics has shown that the provisions were relevant only in respect of 34 cases within at one particular year. And even where the procedure is applicable, the mechanism is often not utilized in practice due to a lack of awareness of this procedure on the part of legal practitioners or obviously parties themselves. And where it is utilized, then it is often applied incorrectly or inconsistently. These findings have come out of a research study, very important, interesting research study on the conflict of courts in child abductions, which was carried out by Professor Paul Bowman and his team a few years ago. So also, where the override proceedings did go ahead and resulted in the return of the child, the actual return was often not accomplished. So another sign that this procedure is not working as it's supposed to work. So now quoting from the research study conducted by Professor Bowman on the conflicts of courts, their research showed that out of the known 63 proceedings, which were initiated between the 1st of March 2005 and the end of September 2015, so only 63 were identified. And out of these, only 7 resulted in the actual return of the child. So against this background, I believe that the second chance procedure should have been abolished by the recast regulation. And in my view, it was a missed opportunity to really simplify the Brussels IIa child abduction regime and in this particular respect, bring it back in line with the 1980 convention. Nevertheless, the override procedure following a refusal to make a written order remains in place under new Article 29, although it is a slightly, in a slightly modified form. So I will now look very briefly at some of these modifications. So first, it seems to me that the major change in the clarification is the clarification that the second chance proceedings should examine the substance of the rights of custody. Although some commentators have questioned this approach, it seems to me that these proceedings, these override proceedings, should indeed be a full merits hearing. Because if these proceedings were simply to be just written proceedings, why should such a decision then be allowed to override the initial refusal to return? So it should be full custody hearing, as helpfully clarified by Article 29. So, nevertheless, it has been rightly noted that this still leaves open the question as to whether such proceedings should be put on an equal footing with purely domestic cases, or whether they should be treated as Hague Convention cases. So, for example, Professor Lowe proposes to favor the approach that they should be treated as Hague Convention cases, both from the point of view of giving such cases priority in terms of timing, and also with regard to the availability of legal aid applicable to convention cases in many member states. And I personally concur with this proposal, that even though these proceedings are full custody hearings, they should be treated in a different way from purely domestic cases. Okay, now the second change or modification that can be observed in relation to this override mechanism is that it no longer applies to all Article 13 exceptions. been confined to only Article 13b and Article 13.2 refusals to return, as Thalia has already pointed out. So overall, narrowing down the scope of the procedure is to be welcomed, but I do agree with Thalia that Article 13.2 should not have been included. So the procedure should have been applicable only to Article 13b for the reasons that Thalia explained. Also, what seems to me sort of strange at a practical level, Article 29.1 says that this article shall apply where a decision refusing the return of a child to another member state is based solely on point B of Article 13.1 or on Article 13.2 of the 1980 Convention. So what I'm looking at is the word solely. I find this a bit intriguing because it seems to disregard the reality that many refusals to return are relied upon more than one reason, more than one ground. And in fact, for example, in child abduction cases involving allegations of domestic violence, Article 13.1b is often made out successfully in conjunction with child protection defense. So does this mean that in these sort of cases will fall outside of the scope of the override procedure? Which is an interesting question. And if so, if they will fall outside of the scope of that procedure, then courts may seek to avoid the override procedure by basing their refusals on multiple grounds, just simply adopting this sort of evasive approach. And this multiple grounds could just be a simple combination of Article 13.1b and Article 13.2. And I suppose if this is the case, then this is a consequence most likely unintended by the legislator. Okay, so I'm mindful of the time, so I will try to very briefly now touch on just a couple of, well, a few other points without going into too much detail. So in terms of the definitions, even though the definitions of the rights of custody and the rights of access in Article 2.9 and 2.10 respectively are the same as in the current regulation, it is commendable that there is further elaboration in the recital section. So I thought that recital 18, which clarifies that for the purposes of the regulation, the traditional sort of clear-cut distinction between the custodial and the access parent is not really appropriate, and that a non-custodial parent may in fact be vested with important rights and responsibilities, including the right to give consent to the removal of the child out of the jurisdiction. So I think that this is very helpful, the acknowledgement that even a parent who may be seen just as the access parent or the non-custodial parent may in fact have the right of veto over the removal of the child and thereby have rights of custody for the purposes of the convention. Another point, age limit, just very briefly, I think that it is, even though the recast regulation applies to children up to the age of 18 years, when it comes to child abduction, it is only applicable to children up to the age of 16, which I think is really good because it is in line with the 1980 Hague Abduction Convention, so we can see consistency with the convention being preserved there. Now, very briefly, concentration of jurisdiction, that's something Thalia also touched on. Recital 41 encourages member states to concentrate jurisdiction for child abduction cases. However, unfortunately, no such obligation is or has been imposed. If it had been imposed, then it would have been a useful tool for speeding up proceedings, as judges would be more likely to develop expertise